Good afternoon, everyone. Welcome to the Carlton Fields webinar on our 2022 class action survey. My name is Matt Allen. I'm a shareholder in the Tampa office of Carlton Fields and a co-director of the survey. Our survey looks at best practices in reducing cost and managing risk in class action litigation. This is our 11th year doing the survey. Let me start out by giving you the agenda for the next hour. I'm going to provide an overview of the methodology of the survey, and then I'm going to turn things over to my co-director, Jack Clabby, who will present the survey's findings. After Jack does that, I will return along with Julie Thomas McCabe, who is the chair of our class action practice group. And Julie and I will do a bit of reading tea leaves and talking about some legal trends that we see reflected in the survey's findings. We will then wrap up by answering your questions at the end. You can ask questions by clicking on the Q&A button on the bottom or top of your Zoom screen. We will make every effort to answer questions at the end of the webinar, time permitting. You are also free, of course, to follow up with any specific inquiries you may have after the webinar. We're happy to answer your questions. We are requesting 1 hour of Florida and Georgia CLE credit for this webinar. We will announce the code for you to use to apply for CLE in your state later on in the webinar. As this slide says, the webinar is being recorded for educational and training purposes. This recording may include questions and poll responses provided by or to you during the live event. This recording will be made available after the conclusion of the live event and posted on the Carlton Fields website. Let's talk for just a minute about how the survey was created. We created the survey in response to observations by Inhouse Counsel that there is a lack of quality research into best practices in reducing cost and mitigating risk in class action lawsuits. We're proud of the survey. To our knowledge, this is the only survey of its kind. We designed the survey to be broad enough so that the results reported are meaningful and representative of what companies experience. And we think the results provide relevant and insightful benchmarking information. Now, who was interviewed? The 2022 Carlton Fields Class Action Survey, like the prior surveys, is based on interviews with general counsel or senior legal officers at 411 Fortune 1000 and other large companies across more than 25 industries, including banking and financial services, consumer goods, energy, high-tech, insurance, manufacturing, pharmaceuticals, professional services, and retail trade. Surveyed companies had an average annual revenue of $23.7 billion and a median annual revenue of $14.1 billion. How are the interviews conducted? Carlton Fields retained an independent consulting firm to select the companies and conduct the interviews. The consulting firm provided back to us only aggregate data. Individual responses and company names are kept confidential. As I mentioned, this is the 11th year of our doing the survey, and we're grateful for the recognition the survey has received over the years by media, the Chamber of Commerce, large companies, peer law firms, and even the late Justice Ginsburg of the Supreme Court. The slide on your screen shows some of that recognition. At this point, I'm going to turn things over to Jack, who will present this year's survey findings.
Thanks. Let's go to the next slide. So I want to start with some table setting. What is happening in the market at large with relation to class actions? And then we're going to pivot. We're going to get right into the meat of the survey responses for what is happening with these companies that we surveyed and what they're predicting is going to happen, and then their views as in-house counsel of what are some of the most effective techniques to manage class actions. All right, so let's go to the next slide. All right, so this is generic across all companies that face litigation in the US. We saw an uptick to the largest number we've seen, $3.37 billion and 14% of overall spend on a corporate legal budget. This is the chunk, almost a quarter, 15% of all spending by legal departments is now spending on class action. So this is big money. And so when you have this much money, even small changes in management can have a real cost savings on behalf of these companies. Next slide. This is the growth that we've seen since 2006 at looking at overall spending across all companies that face class actions. The projection is that it's going to go even up more in the year that we're currently in for 2022. So there's a lot of money being spent here. And again, real opportunities for in-house counsel to present savings back to management. The next slide, please. Again, this is sort of aggregate data across a wider pool than our survey results. And you'll see that about 60% of companies in 2021 are facing class actions. The pool we're going to talk about, though, are larger companies and our specific leaders who are working on class actions. That's the peer group that the study mines for its results. Next slide, please. All right, so now we're into the survey results specifically. We're going to talk about some of the types of class actions as a percentage of matter. That's the one column. And then as a percentage of spending. And you'll see on the next slide that we have certain types of class actions where as a percentage of matter, it might be something, but it's a little bit less as a percentage of budget. So labor and employment, which is traditionally towards the top in our survey of open class action matters, doesn't cost as much on a per matter basis as do some of the other types. Products liability and technical statutory violations, depending on how intense they are often seen as sort of that type of matter as well. Let's look at the next slide. Julie, what's different about securities and antitrust actions that makes them more expensive on a per matter? Just on the, I think unmute Julie too.
Thanks, Jack. So yeah, we've seen this before where there are certain matters that are, or certain categories of matters that are less of a percentage of the overall pie of class action work, but they take up more of the spending. And definitely securities litigation falls in that category, as do antitrust matters, as you can see on this slide, as reported by our survey respondents.
Great, let's look at the next slide. So this is class action breakdown. So of the survey respondents who are managing class actions, what type do they have? And this is going to be a theme throughout this year's survey findings, that labor and employment is both grew in 2021 and is anticipated to grow further into 2022. Consumer fraud contracted a little bit in 2021, but is also anticipated to grow in 2022 as well. For insurance, what we saw that explains, I think, this big jump from 2020 to 2021 is the sort of rise of the class action related to COVID, where it might be a business interruption claim. Some of these were brought in 2021 and resolved the same year. And so that's a spike that affects insurance companies quite specifically, and some other financial services as well. What do you think about the COVID-19? That's an interesting one as well, Julie.
So, right in the survey book, we have our COVID litigation map that we've maintained for the last few years since the pandemic started, and that the blue bar there is 2021 percentage of matters, significantly down from last year. And what we've seen is that COVID class actions are really becoming sort of a way of life for companies right now. So some of them have gotten enveloped into these other categories where companies consider COVID class actions part of their a labor COVID class action may have been enveloped in their labor employment answer, or an insurance class action may have been included in their insurance answer. And at the same time, we also think that this reflects the fact that COVID filings are down, that this litigation has matured, and some of those cases have actually even been resolved at this point, either on the merits or through settlement.
So I think for this, it's going to be, and we'll talk about data privacy as well a little later on, but I think for COVID and maybe for data privacy, we're seeing learning to live with this as something that may be happening for the next several years, and will become a part of doing business for the in-house counsel who manages class actions. All right, so now we're going to move into some of the predictions, and these are some of the more powerful, I think, peer review pieces for in-house lawyers to really think about, because this is what your peers from larger companies that face class actions are thinking are the next wave. Let's look at the next slide. These are some pretty powerful results here. I mean, these are significant, large jumps from 2020 to 2021. The clear front runners for what's going to be the next wave, as predicted by Inhouse Counsel, are labor unemployment and consumer fraud. This is just a huge jump for what folks are experiencing and anticipate experiencing for labor and employment. This is wage and hour litigation. It's employee classification litigation. You've seen some plaintiffs' attorneys have matured their models for what these cases look like, and they're now able to move more quickly from an identified plaintiff and an identified problem to a potential class action litigation. And so I think we're going to see more of this before we see less of this. And while class actions in labor and employment have typically led to charge in our survey in terms of on a yearly basis what's filed, this is a substantial finding for them being the next wave. Consumer fraud itself as well, a substantial finding here as this being the next wave, where you see, I think, concerns from our survey respondents about social media presentations and advertising, direct interaction with consumers through sort of less communications that are not as well blessed as maybe a piece of print advertising would be when you're making these communications. There's also a lot of concern about environmental, social, and governance communications to the public being brought as a consumer fraud claim. We saw a drop in data privacy and security, and I think it's really interesting and has a couple of causes for it. It's still substantial, so it's still one of the top three in terms of what the next wave is going to be. But I think there was a couple of things behind that. One is labor and employment and consumer fraud were so much a part of our life in 2021 and are predicted to be such a part of it that just took away from what data privacy might be. We also did not see, I think, what was anticipated last year was going to be that a number of different states were going to follow California by giving a private right of action and by maturing their sort of statutory ability to bring a lawsuit for damages under state law. Now that may yet come, but I think it's moving a lot more slowly. We recently, actually yesterday, our law firm put out something on a new release from the SEC for public companies that's going to require disclosures of material data security events in a Form 8K within 4 business days of it happening. So I think we're going to see a little bit more of an uptick from that for public companies. And we're also going to keep a close eye on whether the states are going to be following California after all, but a little bit less of a concern. And again,
I just want to jump in on that because historically, companies have predicted data privacy and security, which envelops both data breach cases and data privacy type cases, sort of like, the release of data or the improper holding of data. Historically, in this survey, that category has always been predicted as one of the top categories of the next wave. And this is one of the years where it's gone down the most, even though it's still a quarter, it went down fairly substantially. So I think the concerns about labor and employment and consumer fraud really took away from that this year. And I'm sure the reasons that you mentioned are also a part of that. So it's just an interesting mix and an interesting change that I see from what we've seen in past years.
That's right. And we, the three of us have worked on those over the past several years. And when we do, sometimes it is a one and done. So I think part of that is companies that have been hit by a class action, move through it, resolve it, and move on. And so it's possible that those folks are now thinking, okay, it wasn't as bad as you thought it was going to be. Let's focus our risk predictions on something else. And the COVID-19 dropping, I think is just naturally, as many of the companies have been hit with these COVID-19 class actions, they've moved through them. And again, it's not something that they're pivoting now to what's next, and what's next is labor and employment and consumer fraud. Let's go to the next slide and talk a bit about this labor and employment. This is a really, I think, fascinating survey result as well. This is the percentage of survey respondents who have faced a class action for employment in the last 5 years. Now think about this slide in comparison to what we've already seen in terms of the uptick in actual class actions that the survey respondents have seen. You're now seeing more labor and employment class actions against less total companies. So what that means is if you're a company that's facing these, you're bearing more burden that's distributed among less companies now. And so I think that's pretty interesting. And our survey respondents also communicated that some of the settlements they had for labor and employment, included taking some actions to make sure that they weren't going to be a target again. So I think for takeaways from this, there are things you can do now to review your wage and hour practices, employee classification practices, disability classification practices that can take you off of, decrease sort of the vector of risk for having one of these cases filed against you. Let's take a look at the next slide, please. All right, now let's sort of turn in-house and look at what the in-house sort of workload is looking like on the next slide. All right, so this is the projected workload for 2022. This is what in-house counsel anticipate facing. And you can see, let's look at the next slide. So this 11.2 number, which combines carryover class actions from 2021 in the predictions, is the highest we've seen since we've started the survey. And so there was a lot of settlement in 2021, but it wasn't enough to clear out all of the backlog that was carried over on an average basis. That plus the predictions is looking at sort of the highest caseload since the survey has started for in-house counsel. Next slide, please. So this is the same data we just looked at on the prior slide, but it's broken into two components. The yellow is the carryover from what in-house counsel brought with them from the prior year. And then in all but the last bar graph, we're looking at the blue being the new class actions on average that were added that year. The 3.3, which is in the rightmost column, is a projection or a prediction on what's going to be happening that year. So you see the breakdown. It's a lot of carryover matters that everyone's starting 2022 with, and it's the anticipation of between 3 and 4 new class actions. So again, for the carryover too, some of these settle during the year. So the 6.2 doesn't carry over to all be 7.9. It could include new class actions that were filed in a given year. All right, let's look at the next slide, please. All right, this is also interesting too in terms of what in 2022 was faced by in-house counsel. And this is, I think, some good news. So let's look at the next slide. All right, so to start here, you saw 2020 to 2021. 2020 had a lot of high-risk matters and a lot of bet the company matters. These bet the company matters, as a percentage, it takes up way more resources than counting it as one case, right? So if you have one bet the company matter and 9 nuisance matters, all of them are class actions. Think about how you might spend your time, right? You should be spending a lot more of your time, and probably do, on the bet the company case. That was, severely went down between 2020 and 2021. A lot of these, I think, were the business interruption cases that were filed against insurance companies that may be resolved or went down between 2020 and 2021. But I think this is good news for in-house counsel. And you saw the uptick in lower exposure matters. Those lower exposure matters also provide a little more opportunity. Let's look at the next slide. That those lower exposure matters, if that's going to be the lion's share of what's coming next with consumer fraud or labor and employment class actions, those present a lot of opportunity for in-house counsel to use alternative fee agreements, bundling cases, early settlements, some of the techniques that may not be appropriate always for a bet the company matter to sort of control the legal spend. And it also maybe explains how in-house counsel can do more with less, how they can face the more class actions that are anticipated to come in 2022 without really having to change headcount. Let's look at the next slide. Yeah, so this is the challenge. This is the challenge for in-house counsel now, is essentially this question comes from our asking, how many folks or full-time equivalents are dedicated to class actions? And you can see from 2018 to 2021, it's been going down. And again, the companies that are responding to these survey are the biggest companies. They're companies that face class actions, and the resources in-house are going down. From 2018 to 2021, it's the equivalent of one full-time attorney. I think we all know that one full-time attorney in-house dedicated to class actions, who knows what she's doing, is a powerful resource, and that's being taken away. So what happens as a result of this? There's more reliance on outside counsel, more looking to alternatives to direct management, and less time spent per case by the in-house counsel. At the same time, we've also noticed turnover, and our survey respondents have pointed to turnover in in-house counsel. Let's look at the next slide, please. In terms of the resources that are available, let's talk about the graphic on the left and then the graphic on the right. On the left is, of the companies who are facing class actions, how many have class actions that are covered by insurance? So in 2021, it was about a third. And then we ask of those companies, so of the third, what percentage of your costs to manage the class action are covered by insurance? And so what you're seeing here is less companies are availing themselves of insurance coverage for class actions. And of those, a higher percentage are finding that the class action costs are being paid for. So maybe it's a savvy buyer scenario here, but I think the takeaway here is that it's really, it's going to be company specific, but talk to your broker, maybe sit down with the survey results here that talk about labor and employment being the next wave, data privacy being the next wave, and consumer fraud being the next wave, and play out some scenarios and think through whether it's an opportunity to adjust or to enhance your coverage, if that's something that you expect to be there. So I think that's one takeaway from the survey. You can take sort of this information, combine it with what's coming next, and have a good conversation with your broker about where you are and where you anticipate being. All right, let's take a look at the next slide, please. Talk a bit here about settlements and what happened in 2021. Next slide. All right, so this is a big finding here, a big jump in 2021, 15% or so. And I think this has a couple of, what the survey respondents told us was that this has a couple of different causes. The first is plaintiffs. In 2020 and 2021, they saw their timelines at risk because of COVID, had some older cases there, and wanted to get a resolution done. And on the defense side, on the in-house side, what we were hearing was, it was a little bit easier to settle some of these lower risk cases that popped up in 2021. There was also turnover in in-house counsel roles in 2021, which led to a re-examination and maybe a clearing out of the backlog. So you had a meeting of plaintiffs who were motivated to resolve on the one hand, and defendants who were motivated to resolve on the other. And that, I think, led to some of the jump. Let's look at the next slide. So one thing we also saw in 2020 was, sort of, next slide, please, actually. There we go. So this is sort of the sort of red line represents what we think is the rough mean here. We saw a big jump in 2020 of individual resolutions on an individual basis. And so that, I think, was the panic in 2020 of, courts are shut down. What are we going to do on both the plaintiff side and the defendant side? And so there were some individual settlements as a result of that. 2021 kind of brought it back to what we were more historical, what we saw more traditionally or more historically in the survey data, was that individual settlements are about 40% over time. All right, next slide, please. All right, so cost control and the use of AFAs. We've asked about this, essentially since the inception of the survey, because as a way of finding out, what do peer in-house counsel think are most effective in terms of getting some cost savings done here. Next slide, please. All right, so this is a big and I think somewhat surprising finding for a lot of in-house counsel who are looking at this. Over the past 3 years, we've seen a fairly steep decline in the use of AFAs for class actions. And what we heard from the survey respondents this year was that this had a couple of causes. First was turnover of either in-house counsel or outside counsel made it harder to have that trust relationship that often, is the predictor of whether good AFA can be accomplished on a larger and more complex case. And I think the second finding here is that this is a real opportunity. About 40% now are saying that they used AFAs in 2021. Well, now we know from the survey that labor and employment and consumer fraud are anticipated to be the next wave. Some of those can be sort of bundled class actions or can be the sort of low risk commodity class actions that can be handled by one firm, can be handled over time by the same firm, and that can allow for that kind of trust relationship to get a good cap fee, a good bundled fee in place. So I think this is an opportunity if you are a company that is touching sort of the lower risk matters, to have a conversation with your outside counsel about whether it's time to put an AFA in place for those lower risk matters. Next slide, please. All right, so these are the successive alternative fee AFAs. So what we're really looking at here, again, is these are of the AFAs that you used, which are successful. And so I think the first three here are the kind that need predictability, that need volume maybe, or bundling, and trust. So these are the ones that work well because they have a fixed budget, but at the same time really do need that relationship between in-house counsel and outside counsel, that and frankly, a lot of knowledge about the kind of case that's being there, and isn't always appropriate for sort of a more complex or about the company kind of action. And then the sort of next three, the success fee, the negotiated rates, and the blended rates, those are three that are generally available even in the more complex or about the company actions. And so if you think about these as tools in your quiver to deploy against the risk that's coming, if we're looking at a lot more cases, but of a lower risk, you might find yourself in the top three. And if you're looking at more about the company, more high risk or complex cases, not a lot of information about what's going to be happening, uncertain who the experts are going to be, you might be looking at success fee, negotiated rates, and blended rates. All right, let's look at the next slide, please. This, I think, is the most important sort of slide for what you can do to sort of build efficiencies from the survey findings. And this is at page 32 of the actual printed survey and the electronic copy, which all of you have or will be getting. This is page 32. So this shows the effectiveness wheel, we call this. And this is something that I want to just print out and I want to give to everyone as a blow up, because I think it's really powerful as to what works and what doesn't as a bottom line. All right, so in the blue, in the upper left-hand corner here, you have the highly effective ones. Using trusted outside counsels almost at, it's 98%, and early case assessments at about 93%, right? These are things that are really hard to achieve, but when they work, they're super powerful. Early case assessment, right? Don't just go into a new complaint and think, okay, what's our motion to dismiss basis? Early case assessment is, let's put a little bit of investment up front, do actual fact interviews. Are we doing something wrong that we can immediately fix and nip this in the bud? Give ourselves a new defense we don't know that we have. So these are things that your peers are identifying as really working. As we move down the effectiveness wheel, one that I think is really surprising given the prevalence of it is issuing more RFPs. That's at a 16% effectiveness rate. I think, a lot of times the RFPs, the idea that we're going to do another RFP for an in-house counsel, it is something that is relatively straightforward to do, but it's a high administrative burden. And often it comes from parts of the organization that are not the in-house counsel department itself. So if this can be helpful to you, if you want to push back on doing more RFPs, take it, slice it out of our print copy and hand it over to the CFO and say, let's have a conversation about what's working and what isn't working among our peer groups and why we're doing yet another round of RFPs when that isn't identified as a technique that ends up working in terms of reducing costs. It just swaps out counsel for another counsel we don't know and is not something that tends to work as well. There may be ways to do it that are better targeted, but generally your peer in-house lawyers are not identifying it as moving the needle. All right, let's go to the next slide. I just want to wrap this part with some of the findings we found for COVID. Next slide, please. This, I think, is really, really something. You cannot overestimate the impact COVID had on class action filings in the United States. 1 out of 4 of our survey respondents had one. That's really, really important and a huge, it's sort of a huge part of the experience that all these companies were facing. And a lot of laws getting made sort of abruptly and in real time about how these are going to play out. It's calming down, as you saw from the survey finding, and what's coming next, but it's still going to be a part of what we're facing. Let's go to the next slide, please. All right, and what are these comprised of? A big chunk here in orange were these insurance claims strictly against insurance companies. A lot of those were brought over the past 18 months, and a lot of them have been resolved. False advertising claims come from, what are you telling me about a product, and is it going to work to actually, help prevent COVID? but it also includes within that, you promised me a service or a good, and it's not here, or you couldn't provide it the way you told me you were going to provide it. And the defense essentially is because of COVID. The employment claims are really what was driving it. And, those had a lot of different sort of features or causes to them, but the vaccine mandate, work from home policies, it was also blended in with workplace safety concerns, and workplace discrimination based on approaches to handling the pandemic. So I think that's what we're seeing. But I think generally, these employment claims are part of the overall wave of employment claims we're seeing. What's happening next? I think we had a question about what are these employment claims more generically. I think it's going to be what we've been seeing for the last 18 months. I think it's mature models that have been used for the past few years that are really pithy now about clock in, clock out, claims. I think it's going to be claims about, independent contractor versus employee, so employee designation claims. And I think it's going to be just pure wage and hour claims. And so we have some more mature thinking on it, but I think that's sort of in summary what we're looking at. And I think you're going to see workplace discrimination claims potentially brought based on long COVID. So I think that's a tale that is going to be COVID driven now that, there's new science coming out, may or may not be accepted, but there's new science coming out that may premise some claims on essentially disability claims or discrimination claims based on sufferers of long COVID. All right, let's go to the next slide. All right, so Matt, just you and Julie, take it from here, kind of talk us through sort of some of the law that's popping up and is important for the in-house counsel folks to know about.
Thank you, Jack. So now Julie and I want to spend just a few minutes talking about some commentary on case law developments that may be reflected in the survey's findings. So keep in mind that the survey provides insight into what corporate counsel at large companies are thinking. And the way I look at it is the value of the survey is to act as a sort of peer review of how your colleagues are looking or handling the same type of matters. But now we want to look at some legal trends that may inform some of the survey's findings. So as Jack mentioned, survey participants believe that the next wave of class actions will include labor employment, consumer fraud, and of course, the ever-present concern about data privacy suits. Littler has published some data showing that since March 12th, 2020, there have been 5,432 lawsuits, including 625 class actions filed against employers due to alleged labor and employment violations related to the coronavirus. So the concern expressed by our survey participants is validated. However, in an interesting juxtaposition, as Jack mentioned, our survey also reports that the respondents believe companies are becoming more skilled at avoiding labor and employment class actions. And an increased use of arbitration clauses in employment contracts may be driving at least some of that conclusion. So last year's survey showed that 78% of companies included mandatory arbitration clauses in their contracts. Now that's not just employment contracts, that's consumer contracts as well. That's the highest percentage since the inception of the survey 11 years ago. Last year's survey also showed that 74.4% of companies reported including mandatory arbitration clauses in their contracts, up from 55% from the year before. So because of these high numbers, we didn't ask the question in this year's survey about the percentage of companies using arbitration clauses and class action waivers in their contracts. But I do wonder whether the increased use of arbitration clauses, particularly in employment contracts, may be driving the conclusion that companies believe that they're getting better at avoiding labor and employment class actions. You see on this slide the evolution of the Supreme Court jurisprudence on class action waivers in consumer and employment agreements. In 2018, in particular, in the Epic Systems case, the Supreme Court ruled that an employer can mandate the use of class action waivers in employment contracts. And the court ruled that the National Labor Relations Act doesn't displace the FAA because the NLRA doesn't even mention class actions. A word of caution, however, drafting matters. In 2019, in the Henry Schein versus Archer White case, the Supreme Court unanimously ruled that arbitration agreements must be enforced according to their terms, and there's no wholly groundless exception to confirming an arbitration award under the FAA. In other words, if the parties delegate so-called gateway questions of arbitrability to an arbitrator rather than a court, that decision will be respected even if the arbitrator reaches a demonstrably wrong decision on whether to certify a class in arbitration. So even if an arbitrator permits class arbitration on specious grounds, as long as the decision is committed to the arbitrator by the contract, the court will not save the company from its own drafting. So the takeaway for companies should be to carefully examine your employment agreements and your consumer contracts as well, for that matter, to make sure they contain clear prohibitions against class actions, collective actions, and class and collective arbitrations, and that they mandate that a court, not an arbitrator, will decide the gateway question of class arbitrability. Before I go on to the next point, since we're on the topic of arbitration, let me turn the mic over to my colleague Julie to talk about the Taco Bell case that's currently pending in the Supreme Court.
Thanks, Matt. Actually, we just got a question whether we asked about mass arbitration, and that's a good question, because one of the things I wanted to mention is that so arbitration isn't necessarily the the savior for companies and employment disputes in particular. One of the reasons is because, of course, you don't have any appellate rights from an arbitration result. But also, if you ban class-wide arbitration, what we have seen on some occasions is that employers end up in the situation of a sort of death by a thousand cuts, because the employees are all in one spot and they're easy to find. And so if every employee has to litigate their employment claim in a single person arbitration, you can have a series of successive claims filed against you that ultimately becomes more expensive than a collective action. So that's something just to be aware of as an employer who's sued in an employment case, is whether or not in your situation arbitration is what you want to do. I think it is always helpful to have the arbitration clause in the agreement. It gives you the option to arbitrate if it is going to be less expensive and help to get the claims resolved quickly and inexpensively. However, that brings me to the Morgan v. Sundance case, which is pending before the Supreme Court, and oral argument is scheduled later this month, just in about less than a week. In that case, the employer, Sundance Inc., which is owns about 150 Taco Bell franchises, was sued in a Fair Labor Standards Act employment litigation collective action. And the claims were that the employees were not being paid properly. There were a number of illegal practices alleged, including that some of their hours were moved from one week to another in order for the employer to avoid paying them overtime, that they were asked to work off the clock, those types of common employment claims that we see. And so there were two cases filed. One was in Iowa, one was in Michigan. And so what Sundance did in the Iowa case was, first they moved to dismiss on a quasi-jurisdictional ground under the first filed rule, told the court, look, this Michigan case is already pending. This case shouldn't be here. You should dismiss it. And the district court judge said, no, I'm not going to dismiss it. He denied the motion to dismiss because he said that the Michigan case was a statewide case and the Iowa case was a national class case or national collective action. So he didn't dismiss it. So then they answered. And this all happened within about a 9-month period. The motion to dismiss was filed. The motion to dismiss was denied. They filed an answer and asserted affirmative defenses, but didn't mention arbitration. Then they subsequently tried to do a mediation with the lawyers from both the Michigan and Iowa cases. They settled the Michigan case, but not the Iowa case. And then they moved to compel arbitration. Well, the district court said they had waived their right to arbitrate by engaging the litigation machinery. And waiver is a defense to an arbitration, motion to compel arbitration. So they lost in the district court. The district court said they had waived and they had to litigate the case. They took it to the 8th Circuit, which reversed, saying, look, this motion to dismiss was on a quasi-jurisdictional issue, and then nothing really happened. They attempted to resolve the case without litigating or arbitrating. and filing an answer is routine. So they didn't really engage the litigation machinery significantly before moving to compel arbitration, and the plaintiff didn't show any prejudice. And so the district court's decision was reversed. Plaintiff was compelled to arbitration and filed a cert petition, which the Supreme Court has now taken up. And the interesting question in the cert petition is whether or not requiring prejudice to show a finding of waiver of arbitration by a plaintiff is putting arbitration clauses on better footing than the other terms of a contract. And the Concepcion case, which is the 2011 case here on the slide, held that arbitration agreements have to be enforced the same as any other type of contract. So what the plaintiffs are arguing is sort of that this rule by the Eighth Circuit doesn't comply with Concepcion because it puts arbitration clauses on a better footing than other types of contracts. So it'll be interesting to see how that case pans out and where we go from here.
Let's go to the next slide. All right, Jack also reported that survey participants expressed a concern about a rise in consumer fraud cases. One factor that may be driving some of this concern, at least, involves the trend in the courts toward weakening the unwritten ascertainability requirement for class certification. Now, Rule 23, of course, requires a plaintiff seeking to certify a class to prove the well-known requirements of numerosity, commonality, typicality, adequacy, and for damages suits, predominance and superiority. But along with these express requirements, courts recognize an implied requirement that class membership be ascertainable. Courts adopting the weak view of ascertainability require only that the class definition be adequately defined and clearly ascertainable, reserving actual membership decisions by specific class members until back-end proceedings that ostensibly will occur after a class-wide trial. The First, Third, and Fourth Circuits have adopted a heightened ascertainability requirement. Under this view, plaintiffs have to show at the class certification stage that the proposed class is defined with reference to objective criteria and then that there is a reliable and administratively feasible mechanism for determining whether putative class members fall within the class definition. The Second, Sixth, Seventh, Eighth, and Ninth Circuits have adopted the weak view. In 2021, the 11th Circuit, which had formerly adopted a strong version in the unpublished Carhue decision, issued a published decision in the Cherry case, switching to the weak view. Now, this matters in consumer class actions because often in those cases, consumers and the retailers they purchase from don't retain records of their purchases. And if they don't retain records, there's no way to identify who's in the class. So in the parlance of the strong view of ascertainability, there's no administratively feasible way to determine who is in the class. However, on essentially textual grounds, the trend is away from the strong view and toward the weak view. We think this will increase the exposure of companies in consumer class actions because the weak view makes it harder for defendants to argue that a failure of consumers to retain records defeats predominance, which of course is required for class certification. Now, Jack mentioned a couple of times business interruption cases. So corporate counsel expressed concern about COVID-19 class action lawsuits. The business interruption cases, as Jack mentioned, are falling by the boards. On March 7th, the Fourth Circuit joined the 2nd, 5th, 6th, 7th, 8th, 9th, 10th, and 11th Circuits in ruling against businesses who seek insurance coverage for lost business income resulting from the COVID-19 virus and state government orders shutting down non-essential business functions in the spring and summer of 2020. The federal courts virtually unanimously, have held under various state insurance laws that the typical policy language requiring a physical loss or physical damage covers only losses caused by material harm to the covered property. And because these insurers did not suffer a physical loss resulting from the pandemic when their businesses were shut down, the courts say there's no coverage for pandemic shutdown related losses. Next slide, please. Survey participants also reported a jump in claims made settlements. Let me give you a helpful resource, both for inside and outside counsel, which is a 2019 FTC study of claims-made settlements. You can read the study on the FTC's website, and we have the URL up on this slide. This was a study of 149 consumer class action settlements using data from class administrators. The FTC staff concluded that overall claims rates in consumer class action settlements was less than 10%, but it makes a difference how the notice goes out. Average claims rates for campaigns using notice packets and claim forms is approximately 10%, same as the overall average. But average claims rates for campaigns using postcards is about 6%. Average claims rates for campaigns using email notice is about 3%. Email notice is obviously cheaper than first-class notice packets, but less effective in reaching class members. So there's a point of tension there. By the way, publication notice did not increase the claims rate. There's a lot
Matt,
of, yeah.
Oh, I'm sorry.
No, go ahead.
No, I just wanted to mention that, email notice is, email is becoming the way we communicate as a society. The way that we order things is the way that we, as consumers act. The problem that the FTC reported, or one of the problems they found with respect to the email notices, is that oftentimes they request information and they require you to click on a link. And people are concerned that by clicking on the link, they're going to be hacked or, they're going to click on a virus link. So for that reason, email notices are not as effective as they are easy to distribute and convenient. And it makes sense to distribute notices to email, particularly when purchases were made through email or when the contact information that companies have about class members is in an email. So I'm not sure what the answer is to that, but that was a pretty surprising finding in that report.
Agreed. And the answer may involve simply directing someone to a website so they can go put in their own information rather than clicking on a link. Okay, next slide. Just two more quick points for me before I turn it back to Julie. The first involves challenges to service fees. An impediment to class action settlements has recently arisen in the 11th Circuit. It's a common practice for companies settling class actions on a class-wide basis to agree to pay a service fee or incentive fee to the class representative. And this amount can range from a few $100s to a few $1,000s. In my experience, defendants don't really like to do it, but they recognize that it's a practical cost of obtaining a settlement. But the 11th Circuit just recently put a fly in the soup by striking down incentive payments as a prohibited salary, citing 200-year-old non-class action Supreme Court cases. The reasoning is questionable, and at least one court, as you see on this slide, has explicitly rejected it. There is a possible workaround, which is to pay a separate payment to the class representative as consideration for a general release that's not offered to the rest of the class. We know of at least one court that has accepted this approach. And then finally, for me, one more point, also arising out of the 11th Circuit. Just last week in Rulin versus Holiday Haven Homeowners, Inc., a panel of the 11th Circuit held that a defendant who removes a class action can't appeal a remand order when the district court sua sponte orders remand, because the language of CAFA only allows an appeal, quote, from an order granting or denying a motion to remand, end quote. Because the sua sponte remand is not an order granting or denying a motion filed by a party, the defendant couldn't appeal. This result is in conflict with decisions of the 7th, 8th, and 9th Circuits, which hold that a sua sponte remand is covered by the appeal provision of CAFA. As the 9th Circuit put it in the Watkins case, doing otherwise would be inconsistent with CAFA's clearly expressed intention. So now I want to turn it back over to Julie, who will talk about the Transunion case.
Yeah, just a couple of final thoughts here as we head into the home stretch. So first, I want to talk about Transunion, which was the big class action case that came out of the Supreme Court last year. Of course, it was a 5-4 decision authored by Justice Kavanaugh and fell along conservative liberal lines, with the exception of Justice Thomas, who was on the side of the dissenters and wrote a separate dissent with his views on the issue. But the holding in TransUnion was only plaintiffs who have been concretely harmed by defendant's statutory violation may sue that defendant over that violation in federal court. And what this did was it sort of tightened up the standing requirements as they were discussed and not finally resolved in the Spokio case. And what the TransUnion case was about was it was a Fair Credit Reporting Act case in which the named plaintiff was listed on TransUnion's files as being on what was called the OFAC list. This is a Department of Treasury equivalent of a no-fly list of potential terrorists and such that should not be granted credit in the United States. And Mr. Ramirez, the plaintiff, was not a terrorist. He was an average Joe who's had a very common name, but his name was flagged in TransUnion's records as a potential match. And so TransUnion would send an alert anytime a person who was a potential match sought the approval of a credit application to the creditor. So here, Mr. Ramirez's car loan was declined because of this potential match alert. And he sued on behalf of a class of anyone who was listed improperly in TransUnion's files as a potential OFAC match. What the Supreme Court said, though, was that of the more than 8,000 class members in his defined class, 75% of them were not situated as he was and had not had their information as potential matches disseminated to any third party. And the question before the Supreme Court was whether those folks could be part of a class when their information hadn't been disseminated to anyone else, so whether they were suffering a harm by the fact that their information was incorrect in TransUnion's files, and whether they were suffering a harm because they could in the future have that information disseminated contrary to the statute. And basically, Justice Kavanaugh and the majority found that that's not sufficient. That risk of future harm was insufficient to establish constitutional standing. It wasn't sufficiently concrete, and that eliminated 75% of the TransUnion class. And the dissenters argued that this was wrong and that a violation of a federal statute is sufficient harm in and of itself to establish standing. That battle was essentially lost in Spokio, but it's clearly lost now. And so TransUnion gives outside counsel an opportunity to ensure that a class definition is sufficiently narrow such that obvious class members who obviously lack standing are not included within the definition. Can we go to the next slide? A couple of other unresolved class action issues here. Matt, did you want to talk about the issues classes? I think you're on mute.
Yeah, so an issues class is what happens when the plaintiffs can't satisfy the predominance requirement of Rule 23. Can the court certify issues for specific issues, presumably to advance the resolution of the case as a whole? So you see in this case, it looks like the Supreme Court has this issue. Petition
Yeah,
not accepted yet, right? So petition.
Yeah, it has not been accepted, but it'll be interesting if it is accepted. This is a big problem for defendants where plaintiffs basically try to carve off issues that can be certified from cases that as a whole could not be certified because common issues do not predominate. And as you can see there, the chamber filed an amicus brief in support of the petition for certiorari that cites our survey. And the last thing we want to talk about is superiority. This is a possible issue to bring up in cases where you may have a class action where there are alternative remedies that have been made available outside of litigation, outside of the litigation context, such as through a recall program or through a regulatory settlement that you've already entered into and perhaps commenced, where you have given the plaintiffs everything that they're asking for in the class action. The problem with the superiority defense in that context is that the rule refers to the class action being superior, the class action device being superior to other methods of adjudicating the controversy. And so that word adjudicating is where some courts get stuck when defendants try to raise the fact that there are other remedies available that have already been given. And in some cases, such as a mere sort of value of product case, where the issue has been entirely resolved because people outside of an adjudication have already been offered their money back or provided with a refund. And some courts have recognized that in that case, superiority is not met. Others have really focused on this word adjudicating and said that because such voluntary programs are not adjudications, they cannot be used to argue or find that superiority has not been met under the rule.
So we had a couple of questions come through in the chat to us. If we don't get to your question, you can reach out to Julie, to Matt, or to me, and we'll answer it over email or give us a call. So this is the conversation that the three of us will be having, even if we weren't on a webinar now. So we love talking about this. So please reach out to us if you do have questions. One of the questions that we got was, did you ask at all about statutory damages class actions, laws like BIPA or the TCPA? The BIPA is the Illinois Biometric Privacy Act, and TCPA is the Telephone Consumer Privacy Act. Laws like BIPA or the TCPA have fixed statutory damages that, when multiplied out by thousands of class members, quickly gets the settlement into big ticket litigation, even for technical violations. Wondering if you all are thinking about that. So yeah, we are, and we see this a lot. And BIPA is a scary law. So we did not ask specifically about that in the survey this year, but that's something we definitely can. We see survey respondents talk about this as the fear of what was driving the next wave of data privacy and cybersecurity class actions, because California's data privacy law has statutory damages available to it, even in the absence of real damages, which creates all sorts of interesting issues. I think it's like $100 to $700 per lost record per consumer. And so it is something that is potentially creating standing in the absence of standing under that state law, but we don't specifically ask about it. So that's something we could certainly add. Julie and Matt, any thoughts about that?
Well, I'm hoping that everyone who's on the webinar has received an actual copy of the full survey. This is pretty fulsome, but definitely does not report on all of the data that's reported in the actual survey report, where we do often have statutory violation claims ranked with other types of claims so that you can see where companies are reporting how many of those cases they're facing as compared to other types of cases. So oftentimes, and Jack, as the director this year, I don't know if TCPA came up significantly in the responses this year. In past years, it has. Those cases are, as the questioner notes, usually quickly resolved, and I think most companies have a tight lid on compliance at this point, but it does still happen. So I think TCPA has sort of come down a little bit in the last few years. I don't have the page in front of me right now, but that's my recollection.
Yeah, I think this year's the reporting was we had a breakout for technical statutory violations. It was about 6% of matter share overall. I think there's some disaggregation issues there, though, because I think some would report like a CCPA class action, for example, in California, has the statutory damages component, but they would report that as a privacy and cybersecurity class action. But I got to think about it. I'd like to narrow that down because it does seem to be a real fear of companies that states are just creating standing by passing laws that provide for statutory damages in the absence of real damages. And so I think it might be good to figure out a way to add that to the survey if it's of concern to our respondents. I think we're at time now. So we want to thank everybody for coming. If there are any questions that haven't been answered, you can email them to us and we'll get back to you quickly or give us a call. But I think everybody has the two codes and everything that was put into the chat. But if for whatever reason you don't have it, just shoot an email to any one of the three of us and we'll make sure we either answer your question or get you the technical responses you need for CLA. Thanks everybody for joining us. And we encourage you to read the whole report. It's out now in electronic form. And if you'd like a printed copy, reach out to us. We'd be happy to send it to you. Thank you very much.